Right, in the studio with us this afternoon, it's Attorney Clyde Bennett. And Clyde, go ahead and pull that mic up close to you there, and tell us what's going on.
Well, the development is that yet another juror has come forward and advised me that she felt Judge Hunter was not guilty of anything, including but not limited to count 6 of the indictment. Felt pressured to sign the verdict, and then advised me under oath that Judge Hunter was simply not guilty of any charge in the indictment, let alone count number 6. So she stated that count number 6, the guilty verdict, was not her true and accurate verdict, and she wanted to do something to make it right.
Oh, okay.
I was contacted by her electronically this past Sunday, and she advised me that she learned from the media what was going on with the case with respect to the other 2 jurors. And she stated that she never believed Judge Hunter was guilty of anything. And if she would have been polled, she would have said not guilty in open court. And just like the other 2 jurors, she stated that she was waiting for an opportunity to do just that. The other thing that she mentioned, and again, this is coming from her based on an electronic communication, an email. She stated that there were racial overtones during the deliberations, and there was pressure, particularly by the jury foreman, to find Judge Hunter guilty of something. And she said essentially she succumbed to the pressure when in fact that was not her verdict. And then she didn't use the word relief, but I'm saying it, would seek relief when the jury was polled, and the jury was not polled. She specifically requested that I allow her to come forward, sign an affidavit, and testify in any other form or fashion in order to make this wrong right.
Now, when you say racial overtones, did she go into anything?
She did not, and I didn't examine her specifically on that, but she said the issue of race was brought up in the deliberations.
Any questions from any of the media? Feel free to ask.
I guess it's the same question from last time, and you sort of alluded to it, but when the verdict was polled on Friday, the Friday when it was handed in, the count that was sealed, correct? They were polled at that time, correct, and said this is our true verdict. So what made them change their minds in 3 or 4 days?
Basically, they were not polled on Friday. They were questioned. Polled is when you actually announce what your verdict is, and then you are given an opportunity to have a meeting of the minds in public and open court about whether or not that is your actual verdict. If you recall, on Friday, October the 10th, there was no articulation or publication of the verdict. So when you use the word poll, I don't take that word lightly. I don't think they were polled Friday, October the 10th. I think they were polled. They could have been polled the 14th, but they were not allowed to be polled. What happened between Friday, October the 10th, when the verdict was signed, and that Tuesday, I am not for certain, but I do know from speaking to the other 2 jurors and from speaking to the 3rd juror that was not their verdict, and they had changed their minds between Friday and Tuesday. Now, when they did that, why they did that, I don't know, but I do know that they changed their minds. One juror had actually told me that she wanted to contact me that weekend but couldn't because the case was still going on, and contacted me immediately that Tuesday evening. This particular juror, the 3rd juror that I'm speaking of, she didn't tell me when she changed her mind, but she told me if she was given an opportunity on Tuesday to be polled, she would have articulated her dissent with the guilty verdict on count 6, because in her words, there was no evidence of that, and the charge made no sense.
Would they have been able to stand up in open court and say something? I know it would have appeared to be inappropriate, but would they have been able to do that?
It would not only have appeared to be inappropriate, it would have been inappropriate. As a jury, you just can't stand up and bark out comments or words. You have to follow protocol, and you follow the instructions of the judge. And they were not given an opportunity to do anything. When I attempted to poll, I was denied that request. So you can't expect a layperson just to stand up on their own volition, contrary to what procedure and law is, and state their dissent.
I think this goes to show just what kind of pressure they were under in that jury room. I missed one day of deliberations when the juror was deliberating, and I was told that one of the jurors was in the hallway crying, just crying really bad. I'm like, oh my goodness. Well, I'll be down there tomorrow. I don't want to miss any of the jurors being in the hallway crying. So they had to be under tremendous pressure, and that's just not right. And I think it all goes together when you have a jury foreperson to come out with a press release. I've never known that to be done, but come out with a press release that evidence was convincing and compelling. Who is she trying to convince at that stage of the game when it's supposedly over? So that spoke volumes for her to come out and say, oh, the evidence was convincing and compelling. And I wish people just be honest, because I talked to a lot of individuals, and I mean a lot of Republican individuals or a lot of attorneys that were not necessarily hoping for Judge Hunter to win this case, that were saying, definitely, and these charges, those are gone. These charges are gone. There's way too much doubt in there. And for anybody to come out and say that Judge Hunter was found guilty of every count, I just wish somebody would be honest and say something is seriously wrong in this situation.
And a lot of people may ask, why don't you just shut up, sit down, and go away, and take the sentence and move on with life so we can get back to the way things were? Well, that's inconsistent with the law. You are to zealously represent your client, and you are to do everything legally you can do in good faith. I would be derelicting my duty to Judge Tracy Marie Hunter if I did not bring this to the attention of the court and supplement my previously filed motion, because it further substantiates and bolsters support for a new trial on count 6, because the failure to poll clearly, based on this additional affidavit along with the previous 2, clearly indicates that the failure to poll constituted not just plain fundamental error, but prejudicial error. Prejudicial meaning that it hurts. There's a detriment. And the detriment is, if it would have occurred, she would not have been found guilty of count 6, because now we have not 2, but 3 individuals saying that was not my verdict, and they've stated under oath that if I was given an opportunity to dissent, as a matter of court procedure, I would have. So it's prejudicial. And it's significant. The development is significant, and you have to go forward on it and do what you can legally, because the developments do provide a legal basis for overturning the lone conviction in the indictment.
All right, I need to take a quick break, and then we can come back and finish up. Let's take a break. 12:30. The Buzz.
This weather report is brought to you by TrueCar.com.
Yeah, I didn't know. And I may get to this, you might want to ask, I don't contact jurors.
For today, cloudy with
The timing I'm not responsible for.
I'm sorry, we can't have a news conference in here. I just found out from our legal department. So I hope you got enough, or you can, wait downstairs or whatever, but we have to stop filming.
Okay.
How about that?
I know.
That's kind of weird.
I never heard of
What happened with that? Who
I
called
don't know.
who?
I know.
Wow.
Yeah.
You want the news to be real.
I guess.
We should be able to talk on the show.
Yeah, you can talk on the show.
Guess we can't call it.
I
I
think
don't understand
they would
that.
have to.
I mean, it doesn't, you already got what
Yeah.
Yeah.
It's kind of odd that, why couldn't, we're sort of guests, and you're sort of guests, and we're just having a conversation.
I'm gonna have to call the.
So will this go, just a question, would this go in the next part of the hearing with the other jurors?
Yes, it is. I'm going to supplement
So we fold it into
the
that.
previously filed motion.
Thank you. Thanks a lot.
And that's no-
Hey, all right,
that's no
all right, Tom.